Good evening and welcome to the October 14th, 2025 Planning Commission meeting. I'd like to call this meeting to order. My name is Jason Lear and I'm Chair of the Eugene Planning Commission. To begin this evening, I'd like to call on Commissioner Edwards for the city's land acknowledgement statement.
All right, good evening, everybody. Since time immemorial, the Kalapuya people have been the indigenous stewards to our region, building dynamic communities, maintaining balance with wildlife, and enacting sustainable land practices. This land acknowledgement is a way of resisting the erasure of indigenous histories and to honor our native communities by inviting truth and reconciliation. Following treaties between 1851 and 1855, Kalapuya people were dispossessed of their indigenous homeland by the United States government and forcibly removed to the Coast Reservation in Western Oregon. As we consider the impacts of colonization, we also acknowledge the strength and resiliency of displaced indigenous people. The city of Eugene is built within the traditional homelands known as the Kalapuya Ilahi. The Kalapuya descendants are citizens of the Confederated Tribes of Grand Ronde Community of Oregon and the Confederated Tribes of the Siletz Indians of Oregon. They continue to make contributions in our communities here and across the lands. We express our respect for the inherent political sovereignty of all federally recognized tribal nations and indigenous people who live in the state of Oregon and across the nation. Therefore, the Planning Commission recognizes that what we do here today will affect many generations who will come after us.
Thank you, Commissioner Edwards, and thanks to everyone for joining us in this virtual meeting format. Tonight, we're holding a public hearing for the Public Health Standards of Proposed Land Use Code Amendment to improve coordination between the issuance of building permits by the City of Eugene and permitting done by public health regulatory entities for new development in the E2 mixed use employment, I2 light medium industrial, and I3 heavy industrial zones. Anyone wishing to access and participate in the public hearing can do so by following the access instructions listed on the agenda for this meeting. Planning Commission meetings can also be viewed by watching the live stream available on our website or the broadcast on Comcast Channel 21. If you wish to speak and provide testimony tonight, please know that we'll begin the testimony portion of tonight's meeting after a brief presentation from staff. When we reach that point, staff will provide instructions about the virtual hearing format and how to participate. Before we start, I want to let you know a bit about the Planning Commission and our role in the process. First, we're unpaid volunteers appointed by the Eugene City Council who all live and work in Eugene, like many of you. For these proposed public health standards code amendments, we're not the decision makers. Rather, we will review the proposal, testimony, and other relevant materials and make a recommendation to the City Council. The City Council will hold their own public hearing before making the final decision on the proposal. We're at-large members, which means we have to consider the needs of the community as a whole, as well as the needs of all groups and neighborhoods. We're also human beings, which means each one of us has personal views that make us who we are. But as planning commissioners, we're committed to balancing all of our needs as a community and to making the best recommendations we possibly can based on our policies and our laws, for us and for future generations. That can be pretty tough to do, and we know that not everyone will agree with every recommendation we make. So as we proceed this evening, we want you to know up front that we're listening and that we care deeply about you and our community. We recognize how important these changes are and encourage everyone speaking tonight to do so in a respectful and productive way. Now I'd like to invite our moderator, Crystal, to provide some information for tonight's hearing.
Thank you, Chair Lear. Hello, everyone. I am Crystal Fisher, and I'll be the moderator for tonight's meeting. I'm going to cover a few items before we begin with regular proceedings. Firstly, I want to thank everyone for joining us in this virtual hearing and note that tonight's hearing is being recorded. Since we're meeting virtually, I'm going to provide specific instructions on how to request to speak before we begin the public testimony section after the staff's presentation on tonight's topic. So with that, it's great to have everyone here tonight, and I'll hand it back to you, Chair Lear.
Thank you, Crystal. As she said, we'll begin with the brief presentation from Reed Werner and then move on to open the public hearing. Reed, please begin.
All right, just going to share my screen here. Good evening. My name is Reed Werner, and I'm the Land Use Supervisor with Building and Permit Services. I'm here to discuss I'm going to start by providing some project. I'll then discuss some of the challenges and opportunities that emerged throughout the initial work on the project.
Reed, I find you're breaking up quite a bit.
Okay.
I don't know if you can reduce your bandwidth or anything.
Screen is not shared yet either.
Yeah, you're kind of freezing on us. Well, we can give Reed a second to see if he can rejoin.
I'm gonna work with Reed to get him rejoined here. Let me see what I can do to help facilitate that.
Jeff, do you have access to the presentation in case somebody else needs to give it?
Yeah, absolutely. That's not a problem. And Reed's actually in the same building, so if all else fails, he can come sit in my seat.
Well, apologies, everybody. We'll give it just a minute or two to try to work out these technical issues.
Jeff, you might be able to just share the presentation and still have Reed give it. Maybe his computer is, I'm not sure what's going on.
That's exactly what I was wondering as well. Let me just make sure I've got the updated version. I'm hoping Reed will jump on here momentarily. Our apologies, everyone.
Looks like he's rejoining there. Hey, Reed.
Am I back in?
Yeah.
Okay, I probably need to share again here. Sorry, everybody. My laptop died this morning and I'm on a loaner and it's been quite a day adjusting. So I'm hoping that I don't get another crash. Okay, can everyone hear me all right and see my screen on the agenda?
Yes.
Yes.
Okay, did I get through the agenda or was I already breaking up?
All right.
I didn't hear much of anything.
Okay. All right. Let's start back at the beginning here. So here's our agenda for tonight's presentation. I'm going to start by providing some background information and an overview on the Public Health Standards Project. I'll then discuss some of the challenges and opportunities that emerged throughout the initial work on the project. I'll then highlight the direction provided by the City Council on the future work on this project. And then we'll focus on today's item, the proposed land use code amendments related to the improved coordination with our regulatory partners. Please note that we have submitted 2 versions of the proposed land use code amendments, and I'll get into the differences later in this presentation. So for some background, in October of 2023, the City Council voted to initiate the work on an update to the land use code to address community concerns related to industrial development located in close proximity to residential uses. The goal of the project was to rely on technical assistance from a hazard and risk analysis study that the city's Public Works sustainability team was working on initiating throughout all of 2024. While that team was working through some challenges in getting responses to their requests for proposals, earlier this year, we started moving ahead with the community engagement process and started researching the existing regulatory framework for industrial development. On June 18th, 2025, staff presented an update of the public health standards work to the City Council, and the Council passed 2 motions. First, the Council moved to direct staff to draft land use code amendments requiring an applicant to demonstrate that they have been issued all required permits from pollution control agencies like Lane Regional Air Protection Agency or LRAPA and the Department of Environmental Quality or DEQ. As the applicant has applied for the permits, or alternatively, they could show that they have applied for the permits and that the permits were likely to be issued. And this is the code amendment that is the subject of tonight's hearing. Second, the City Council also moved to direct the City Manager that upon completion of the hazard and risk analysis study to draft land use code amendments informed by the results of the analysis. So I'd like to take a moment and highlight that there is some public testimony that's been focused on moving forward with additional changes to the land use code, and any work on those potential changes would be slated for after we receive the results from the Eugene-specific hazard and risk analysis. So here's an overview on the project work so far. We completed the initial public engagement stage of the project earlier this summer. We've also been assessing the regulatory scheme at the local, state, and federal level in an effort to identify any potential gaps in the regulation. The goal is to incorporate the community feedback with understanding of those existing regulations to determine if there are any land use code regulations that could appropriately address those community concerns. Community engagement efforts focused on better understanding community views and perceptions of the issue and whether the land use code is the right tool to help address those concerns. Staff reached out to a broad spectrum of community members, including affected neighborhood groups, businesses, and environmental and community groups. The project team received feedback from a wide range of interested parties, and the views and perceptions shared with the staff were contrasting. The community engagement survey and full survey, or community engagement summary and full survey results are linked to in the AIS, and they are also included in the record materials for these code amendments. As the project team worked through the initial public engagement process and researched the existing regulations impacting industrial developments, some challenges and opportunities emerged. While there was agreement on some concepts and themes, there's typically a lack of agreement in the community on whether land use code changes are the appropriate tool to address concerns with public health. Additionally, land use code changes won't stop bad actors like J.H. Baxter that violated local, state, and federal laws. Another concern is that making changes to the land use code could create non-conforming situations. This could limit the ability of existing businesses to make improvements, including technological updates that could decrease impacts. One of the main challenges is the broad nature of the land use categories in the land use code. These categories don't necessarily represent the potential impact from a use. For instance, a carpenter whose business was cabinet making would be considered the same use as a large cabinet manufacturer. Therefore, it would be a challenge to implement changes to the specific uses without a better understanding of the hazards and risks associated with those uses on a local level. One set of opportunities that emerged as we worked on this project is better coordination with our regulatory partners, including the DEQ and LRAPA. There is currently nothing in the Eugene Code that requires an applicant to pursue the necessary regulatory permits prior to receiving a development permit, such as a building permit or a grading permit from the city. The proposed code changes that we'll discuss in a couple of slides are focused on addressing this specific potential regulatory gap. In addition to these land use code amendments related to improved coordination with our regulatory partners, the City Council directed staff to continue the work on the public health standards projects once the hazard and risk analysis work has concluded, and we have that Eugene-specific data to help inform any potential proposed changes. And now that we've provided some background information and an overview of the public health standards project, we'll turn to the topic at hand for this public hearing, the proposed land use code amendments. As I mentioned previously, staff has provided two versions of the code amendments for your consideration. Version 1 was submitted in early September, and we received feedback from regulatory partners, interested parties, and city staff that highlighted an issue with language related to likely to obtain. Therefore, staff pivoted and provided a responsive draft code update that was included in the AIS for this hearing. However, before jumping in, to get a better understanding of where these code amendments would apply, here's a map highlighting the locations of the subject zones within the city. Now, I know this map can be hard to see. We have a large version of it that's very high resolution available on our webpage. So if you want to look into it closer, you can actually zoom into a tax lot specific level. So take a look at that if you want to get a better look. E2 is in fuchsia, I2 is in pink, and I3 is in purple. The shaded areas indicate that those properties are inside the city's urban growth boundaries, but have not yet been annexed, so they are under Lane County's jurisdiction. You'll notice that the industrial areas in the city are typically located along major transportation corridors. As the city expanded, residential areas filled in around these transportation corridors, with subdivisions replacing much of the outlying historic agricultural areas in Bethel, River Road, and Santa Clara in particular. These historic zoning patterns have led us to the current situation where we have residential uses located in close proximity to industrial lands. While future steps in this project may consider changes to the land uses and development standards, this code amendment is specifically focused on improving the coordination with our regulatory partners. Version 1 of the proposed code amendments provides two ways to meet the coordination requirement before city approval of a development permit. First, an applicant could show that they have obtained all required air, land, and water permits and/or licenses. Alternatively, an applicant could show that they had applied for all required permits and licenses and that the permits and licenses were likely to be obtained. It was the concerns with this likely to be obtained language that resulted in moving towards a second version of the proposed code amendments. Version 2 focuses specifically on air, land, and water permits required by the Oregon DEQ and LRAPA and provides 3 different options for applicants. The first option is the same. They can provide documentation that the permits have been obtained. The second option would be to submit documentation that the applicant has applied for all required permits. And the third option would be to submit documentation that no permits or licenses are required by those agencies. This change helps create a more clear and objective standard, as well as both Oregon DEQ and LRAP have had discussions about the potential for providing informational meetings to applicants prior to permit submittal in order to determine what type of permits are required. Therefore, the city would be able to ensure that applicants are working through all required air, water, and land permits prior to issuing development permits. I do want to clarify that with either version, there would not be a delay in the timing of the city signing off on land use compatibility statements from our partnering agencies, as those are required to start their specific permitting process. So we would still be able to sign off on Lux's depending on the land use table prior to any city permitting. Due to the pivot to version 2, staff is recommending that the Planning Commission keep the record for written testimony open for 2 additional weeks to give the community an opportunity to respond to proposed changes. And we provided some motion language for your convenience. Staff will continue to batch testimony and send it to Planning Commission up to the deadline. Any testimony received after that deadline would not be under the review for the Planning Commission deliberations scheduled for November 18th, 2025. However, it will be included in the record and considered by City Council. The City Council public hearing on this item is tentatively scheduled for January 20th, 2026. And here's the contact information for submitting written testimony for these code amendments. Please note, if you are submitting testimony by email, if you would like to be added as an interested party to get written notifications in the future, to include your mailing address in your email. That's it for me. So back to you, right, Crystal, or maybe Jason?
Thank you, Reed. Appreciate that. Before we open the public hearing, I've got a few more details to share regarding our order of operations. Commissioners have asked for more clarity on when it's appropriate to ask questions, and staff has suggested that if they have questions about someone's testimony, you should ask those questions following that individual's testimony. So if you want to pop your hand up, if you've got a follow-up question to ask after someone speaks, please feel free. Following the conclusion of public testimony, staff will have a chance to respond to the public testimony presented, and commissioners will have the opportunity to ask additional questions of staff. Just as a reminder, the Planning Commission will not make a final decision on this matter. We'll make a recommendation to the City Council, who will hold their own public hearing before making a final decision. As always, feel free to contact staff if there's testimony you were not able to provide in this hearing, or testimony that you wish to provide to the Planning Commission in writing. Before we open the public hearing, Crystal's got some further instructions for us for providing testimony. Crystal?
Thank you, Chair Lear. So hi again, everyone. It's now time to sign up to speak if you wish to provide testimony tonight. You can get into the queue by raising your virtual hand. To do this, please click the raise hand button in the menu if you're joining us from a computer or a smart device. It doesn't look like we have anyone by phone, but in the future, you can dial *9 if you're on a phone. And you can start raising your hands now as I continue to provide instructions. At the start of your testimony, please start by clearly stating your name and your address. I will announce whose turn it is to provide public testimony, as well as announcing who is up next. When you are called to provide testimony, you will be promoted to a Zoom panelist, which will allow you to unmute and turn on your video if you choose. Please do not unmute or turn on your video until it's your turn for public testimony. When your public testimony is concluded, you will be returned to the Zoom attendee status. Regular practice of the Planning Commission limits testimony to 2 to 3 minutes, depending on the number of speakers. I will notify you when there are 30 seconds remaining in your allotted time. When public testimony is concluded, you will be muted. So please be mindful of your time. If there are any technical difficulties encountered during your turn, we'll move on to the next person in the queue and try again after that person's comment. All that said, I will now hand it back to you, Chair Lear.
Thank you, Crystal. So now I'd like to open the public hearing. The purpose of the hearing is to receive relevant testimony on the proposed public health standards code amendments before us. Crystal, how many speakers do we have currently in queue?
We currently have 4 in queue.
Okay, so let's give folks 3 minutes. Based on the number of speakers who wish to comment here, should be plenty of time for everyone to share their views. We encourage people to submit any written testimony as well. Written testimony may be submitted via email, by mail, or in person. More detailed instructions on how to submit written testimony are included in the materials for this meeting and are available on the application notices. We'll now begin public testimony, beginning with the applicant. So Crystal, I'll hand it back to you to begin.
Oh, sorry, that's an error in our script. There's no applicant. But again, I want
to,
yeah, I do want to remind everyone to raise your hand. So it looks like we have 5 now. If you wish to speak tonight, at the start of your testimony, begin by clearly stating your name and address. You'll have 3 minutes to speak. We're going to begin tonight with Joe. I'm going to go ahead and promote you now, who will be followed by Jim. You're also going to receive a request to be promoted to a panelist. And let's see, we got everybody in there. All right, Joe, you are up first. You may begin.
Hello, can everyone hear me?
We sure can, yeah.
Good. Okay. My name is Joe Liebersbach, and my address is 1401 Willamette Street in Eugene. And here we go. So thank you for allowing me a chance to speak, Chair Lear and all of the members of the Planning Commission. I'm Joe Liebersbach, and I am the Director of Business Advocacy at the Eugene Area Chamber of Commerce. And on behalf of the Chamber, I want to thank you for the opportunity to submit comments regarding the proposed public health standards. The Chamber fully supports the city's commitment to protecting public health and ensuring a coordinated permitting environment. However, we do have significant concerns that the current draft introduces uncertainty, subjectivity, and redundancy into a system that Oregon law requires to remain clear and objective under statewide planning goal 9. Our concerns with the proposed amendments are as follows. Lack of clear and objective standards. The proposal introduces ambiguity and discretion where clear measurable standards are required. Rather than improving coordination, it risks creating conflicting processes and timelines between the city and state regulatory agencies, leading to avoidable bottlenecks. Misapplication of land use law. Oregon's land use system is not a tool for criminal deterrence. It was designed to provide fair, transparent, and objective review for lawful development. Attempting to assess likely compliance or the likelihood of a permit being issued turns the zoning code into a predictive enforcement mechanism, an approach inconsistent with state law. Overreach beyond coordination requirements. Under ORS 197.180 and ORS 197.173, local governments must coordinate with state agencies such as DEQ and LRAPA, but each maintains independent authority. The proposed language crosses that line and risks entangling jurisdictions rather than aligning them. The likely to be issued standard is unworkable. No entity, the city, applicant, or agency can objectively determine that a permit is likely to be issued before completion of the public process. This subjective standard is legally indefensible, unpredictable, and exposes both applicants and the city to appeals. Inconsistencies between draft and notice language. The staff explanatory letter refers to actions, quote, prior to issuance of a building permit, while the draft code language says, quote, prior to issuance of any development permit. These terms are not interchangeable under Oregon law. Existing oversight mechanisms already ensure compliance. Environmental permitting and enforcement responsibilities already rest with DEQ, LRAPA, and other regulatory agencies. Economic competitiveness and community impact. Eugene's industrial employment lands are essential to the city's economic diversification, innovation, and living wage job creation. Businesses already navigate a complex environment and compliance systems. The Eugene Chamber respectfully urges the Planning Commission to reconsider or substantially revise the proposed amendments to ensure they comply with Oregon's clear and objective land use standards and preserve the balance between regulatory oversight and economic vitality.
And that is time. Thank you, Joe. I'm going to change you back to an attendee. Jim, before you begin, I'm going to go ahead and announce the next person who's on deck after, and that's Argery, promoting you to panelist now. Jim, you are ready to go. Your time begins when you begin speaking.
Great. Thank you, commissioners. I thank you for the opportunity to comment tonight. The proposed land use code changes requiring developers in E2, I2, and I3 building occupancies is a step in the right direction for public health standards, but should address more specific challenges the city is facing. Foremost, land use code amendments should take into consideration the goals of the Climate Recovery Ordinance in relation to transportation and building use efficiencies when it comes to greenhouse gas emissions and carbon emissions. The goals set by the city to reduce community-wide emissions are not being met in these sectors, and land use amendments could correct these inefficiencies. Renewable energy requirements based on building square footage and vehicle trips could address goals 12 and 13 in attachment C. Equally important is to make owner-developers responsible for health and safety to the community in the event of hazardous materials leaks, explosions, and fires as a result of an on-site event or a natural disaster. Risk bond assurances should be in place and sufficient to meet financial costs to keep the public from being saddled with these costs. It is important that self-bonding would not be allowed as a financial assurance mechanism to cover financial risks. Baxter Industries Superfund site is a prime example, as well as the existing and seismically vulnerable Kinder Morgan tank farm on Prairie Road. Fossil fuel risk bonds would address Goal 7 in the attachment C. Maintaining the air, water, and land resources, quality including preserving farmland and wetlands provides a quality of life for the local community. Documentation of air, land, and water permits or licenses should be required and submitted to the appropriate agencies before project considerations. Thank you again for your time.
Thank you, Jim. Give me one moment here. Alrighty, Arjorie, before you begin, I'm going to announce the next person, Travis. I'm going to be sending you an invite to be promoted to panelist here. Okay, Arjorie, you are ready to go. Your time begins when you begin speaking. And don't forget to give us your address as well.
Great. Good evening. My name is Arjorie Arbery-Barabo, and my name is Arjorie Arbery-Barabo, and my address is 5608 Southeast Woodhaven Street in Portland, Oregon. And I submitted written testimony, but I'm also happy to have this opportunity to speak here as well. Many of you, I see your faces and recognize them, and you know me as a community organizer for Beyond Toxics. That is true, but this issue is personal to me as well. At the inception of this concept, protecting families impacted by industrial pollution was the goal. The Bethel community worked tirelessly, meeting with elected officials, community leaders, and neighborhood organizations to share this vision of a healthier neighborhood. I've spoken many times about being the mother of a childhood cancer survivor. I've heard the heartbreaking stories of my Bethel friends and grew more and more frustrated and angry by how the community's health and livelihoods have been disregarded generationally. I'm speaking today as a community member. Having codes in place to protect public health seems like a no-brainer to me. Don't put industry near people where they live, work, and raise their families. My family is blessed to have come out on the other side of cancer. Many families have not had the same experience. Loved ones have lost their lives by sharing the neighborhood with polluters like J.H. Baxter. Had there been a code like the public health standards in place before her illness in 2018, I believe my child would not have gone through what my child went through could have been avoided. My lived experience and my seat at the table have brought the voices of the community into decision-making spaces, bringing the focus of humanity into a conversation too often only discussed in statistics. I've made it my life's work to fight for the rights of families like my own and families who may not know the dangers that surround them, but who deserve, like everyone else in the city, clean air, clean water, and safe soil in their neighborhoods. I'm grateful that the city has taken steps towards protecting the community, but I'm also waiting to see what comes next. Thank you very much for this opportunity to speak this evening.
Thank you, Arjorie. Okay, Travis, before you begin, I'm going to go ahead and promote the next person, which is Lynn. All right, Travis, you may begin.
All right, thank you. Good evening, Chair and Commissioners. My name is Travis Knutson. I'm a Eugene resident at 2965 Timberline Drive in Eugene, and I'm also the Executive Director of the Lane Regional Air Protection Agency. LRAPA appreciates the city's efforts to strengthen public health protections through improved coordination. We support this goal wholeheartedly and are grateful to be correctly identified as a collaborator on this challenge. I commit LRAPA's interest and engagement on this issue. However, we do have substantive concerns about the procedural workability of the proposed ordinance, concerns I've detailed in our written comments submitted to the Commission. The core issue is essentially on version 2, which creates a procedural loop. The state requires LRAPA to receive a land use compatibility statement from the city before we, as an organization, can process our air permit applications. But the language of the proposed ordinance would require developers to show they've obtained or applied for LRAPA permits before the city issues its permit. Neither agency can act first under this framework. We work collaboratively with the city staff since the summer to find solutions, and thank you to Reed Werner for his engagement, interest, and collaboration. I get the sense that this is important and he wants to do very well, and I'm grateful for that. But our city written comments proposes some specific alternative language that we believe will achieve the city's public health objectives while maintaining legally compliant procedures, which essentially boils down to, instead of requiring permit determinations, we recommend language that requires pre-application consultation with environmental agencies. This approach ensures early coordination, identifies those potential air quality issues up front, and avoids creating speculative liability for either agency, all while protecting public health, which is the goal. LRAPA is ready to implement enhanced coordination procedures immediately upon adoption of a workable framework, and we remain committed to finding a path forward together. Thank you for your consideration. I'm happy to answer any questions the Commission may have.
Thank you, Travis. I'm going to change you back to an attendee here. Lynn, before you begin, let me go ahead and get Jen promoted to a panelist. You'll be up next. Okay, Lynn, you can begin when you're ready.
Okay, my name's Lynn Woodridge. I'm the active Bethel Community Co-Chair. I've lived in the Bethel area over 30 years. I live at 4917 Cone Avenue in Eugene. How is this going to prevent businesses like the biofuels transfer station and the fuel tank farm from locating in a residential area? It's critical that the public health standards with teeth be finalized soon so that the community is able to benefit and public health will not be harmed prior to Georgia Baxter selling the J.H. Baxter site to another polluter. EPA says even city zoning laws make a big difference in what is allowed in reuse. Councilor Leach suggested to narrow the descriptions of the zone designations. The City Council could accomplish this right away. The narrower zone verification requests would give the planners a way to deny the most hazardous businesses. Then maybe we could have had the legal basis to deny the fuel tank farm in the Train Song neighborhood. Putting protective zoning in place would have helped strengthen the city's position regarding the biofuels train to truck distribution center before the company took the city to the Land Use Board of Appeals. Thank you.
Thank you, Lynn. All righty. And Jen, if you are ready, you may begin.
Yes, good evening, Commissioners. My name is Jennifer Davis. I live at 25112 Terry Court in Bonita. I work at 120 Shelton McMurphy Boulevard in Eugene. I also serve as the Executive Director of Beyond Toxics, a Eugene-based nonprofit dedicated to environmental justice. Tonight, I wanted to thank you for taking the first steps toward establishing public health standards in our land use code. This work is long overdue and absolutely vital. Right now, our city has no clear, meaningful protections for residents who live, work, and raise families near industrial facilities. Without enforceable standards, we have seen neighborhoods continuously bear the brunt of toxic emissions, weak zoning laws, and slow responses to contamination. The human costs are real. Families in West Eugene have faced higher rates of cancer, asthma, and other chronic illnesses. Parents have watched their children suffer with preventable health problems. Community members have lost trust in their government because their voices have often gone unheard. These are real lived experiences of people in these communities. This greatly impacts our neighbors' lives, and their wishes and concerns deserve to be heard throughout this entire process. This is why the commission must ensure that the next phase of this project deliver real protections, clear health overlay zones, buffer requirements to separate polluters from homes and schools, and robust review processes that put public health above industrial convenience. You have an extraordinary opportunity and responsibility to ensure that no community in Eugene is left to carry the burden of toxic exposure. By adopting comprehensive, enforceable public health standards, you can set a statewide precedent for fairness, equity, environmental justice, and land use planning. On behalf of Beyond Toxics and the many residents who have lived these impacts, I urge you all to be bold. Adopt standards that will safeguard future generations, that demonstrate that Eugene values human health and thriving neighborhoods over industrial profits. I appreciate the opportunity to speak with you tonight. Thank you.
Thank you, Jen. Okay. Giving one last opportunity if anybody would like to raise their hand and provide testimony tonight. Seeing none, I'll hand it back to you, Chair Lear.
Thank you, Crystal, and thank you everyone for taking the time out of your evening to share your thoughts and your ideas with us. The public hearing is now closed. Before we move on to staff response and commissioner questions, we have a procedural topic to discuss. Staff has recommended that the Planning Commission continue to accept written testimony until 5 p.m. October 28th, 2025. Written testimony received after the date the record is closed will not be considered by the Planning Commission, but will be provided to the City Council for their consideration. And staff has also noted that we may close the testimony now and move on to deliberations immediately. So I wanted to see if anybody had a view to share about whether to propose a continuation of holding the record open until October 28th, or if anyone has thoughts on closing the record now. Commissioner Edwards.
I would thank you so much, Commissioner Lear. I think in response to some of the changes that were made relatively recently, I think that holding the record open for an additional duration of time would be recommended. So I would support that, and I'd be willing to make that motion.
You want to go ahead and make that?
I would love to. So yes, I move that we hold the record open until October, is it 28th?
Yep, 5 p.m.
5 p.m. Yeah.
All right, so we've got a motion to hold the record open for Planning Commission's consideration until 5 p.m. on October 28th, 2025. Is there a Lauren?
Thank you, Commissioner Lear. Can I just clarify? I believe the staff recommendation was to hold the record open for the 2-week period that Commissioner Edwards mentioned for submission specifically of written testimony. So it would be written testimony only, if that is okay. So Commissioner Edwards, I see you're nodding. That's okay to be part of your motion. Okay. Thank you.
Yeah, I'll second it.
Okay, so just to clarify, we've got for written testimony only holding the record open until 5 p.m. October 28th, 2025. The motion has been made and seconded. All in favor, please raise your hands. And anyone opposed? Looks like we have a unanimous adoption of that motion. So we can move on now then. Is there a staff response to the testimony offered this evening before we go on to have commissioners ask any questions?
Sure. I did thank you, Chair Lear, for the opportunity to respond. I did want to talk about the land use compatibility statement that the LRAPA Representative Travis Knudsen brought up. There's a little bit of confusion about we call them LUCs for short. When an applicant starts their permitting process through LRAPA or DEQ or other regulatory agencies, the first part of that is for them to check with the local government to confirm that the land use that is proposed is allowed within our use table. So that occurs prior to any city permitting process, whether it be site development permits or building permits. We do that check by checking the land use code table to see if it's permitted use. If it is, then we sign off on it and give it to the applicant to take back to the regulatory agency. So these changes would impact when a building permit or a development permit, which can include grading or other site activities that don't actually rise to the level of a building permit, they are all included in a development permit. That is a separate process than the signing off on the LUX process. So this proposal would not change the timing of LUX's currently under either proposal. know if anyone else had anything else to add. Jeff or Alyssa?
I'll just jump on really quick. Good evening, everyone. My name is Jeff Gepper, Principal Planner with the Planning Division, here to really just also thank everyone for providing their testimony this evening, and anyone who submitted written testimony. In particular, I wanted to call attention to, I believe it was Joe's testimony. He spoke about the requirement for things to be clear and objective. This is a requirement at the time of building permit. We need to have any of our standards be clear and objective in order for them to be applicable. It was exactly for this reason, actually, that it was kind of flagged that the version 1 and the use of the term likely, I think that's, everybody's like, well, your version of likely is different than mine. And so in recognition of that, that is why version 2 was introduced. And so version 2, in so much as being clear and objective, it just sets a bar for somebody to demonstrate that they have a permit, they've applied for a permit, or documentation that they don't need a permit. And in that way, we can say, did we receive that? Yes or no, which is a clear and objective standard. And so the goal of that is really to provide just some transparency for interested parties who maybe they see a building permit come into the city of Eugene. They might not be as familiar with the regulatory framework. And so they might see, oh, well, they also have to get an LRAPA or a DEQ permit. And then they can go seek that out. It doesn't require city staff to be the ones analyzing and reviewing permits that are not ours. We don't want to pretend to be the experts in air quality or some of the work that DEQ does. So just, that's what version 2 is really targeted at, making things transparent and also being clear and objective. So thanks again.
Commissioner Edwards.
Hey, thanks, you guys. I just had a couple questions, just technical questions, and I'm not sure if Reed or Jeff would be the person, maybe even Lauren, but I am curious about a couple of things. Specifically, do we have any sort of idea or sense as to how many businesses are operating without permits, having obtained permits? I mean, are there businesses, do we know, has DEQ or LRAPA or EPA or anybody reported back that there's a problem? Because while this process would ask for coordination, do we know that there are folks operating without the proper air, land, and water permits?
I can speak to that one. There's no specific quantitative evidence regarding this, but there is anecdotal evidence in our talks with LRAP and DEQ that there have been instances where applicants come to the city, obtain building permits, start development of the site, and then are later complained about, and then they find out that, they didn't start the LRAP or DEQ permitting process that was required. So anecdotally, it does happen, but I don't have any quantitative evidence about that.
Okay. My other question, and I'm sorry, and then I'll let Commissioner Beeson move on. Oh shoot. You know what? Let him go. I'll come back to it because I wrote something. So I'll get in the queue again.
Okay. Couple of questions. Well, first off, thank you to everyone who provided testimony. Appreciate it very much. Thanks, Reed, for all of the work on this. I know we've talked about this a few times, and I know there's a lot involved, and it gets fairly complex. I also, I guess, briefly as I was going through the community survey summary, community engagement summary, it struck me, I want to say two things. One, it's very well organized, and I think all of the material in there, it's very helpful. I appreciate that, Reed, and to whoever the other staff that put all that together, whoever it was. It's very good, and kind of extend an appreciation to all of the people who you met with, who I don't think of it so much, I guess, as testimony, but they provided a great deal of input for us, and it's a very worthwhile document. I found it to be. So a couple of questions. You reference in the material the hazard and risk assessment That was talked about at some length at the June council meeting. At that time, that was kind of a approximate estimate for completion on that was out about a year. Can you tell us the status of that and maybe an update on when that work might be expected to be done?
And thank you for the question, Commissioner Beeson, and for the comments about the public engagement. That was very eye-opening to speak with the community about this project. When it comes to that risk and hazard analysis, we're still working off of the indications from the Public Works Sustainability team that those results would be estimated in 2026, and have not received any specific update of different timelines for that.
So we might, we don't need to go too far down this road, but I mean, we have a recommended code amendment here in front of us. We've had the hearing about, and we're going to deliberate about, and so on. And I'm kind of assuming that once that work is completed at some point in the future, there may be additional land use code amendments brought forward by staff.
Yes, that's correct. So once we do get the results of the hazard and risk analysis, the direction from council is to take another look at the land use code standards and determine whether there's information, any potential regulatory gaps. That's part of the analysis, is going to be a gap analysis too. Other gaps that we have not found with the research we've done at this point, and that those results will hopefully drive the next steps in the project to take another look at the land use code and see if the results of that study warrant any or inform any additional changes to be proposed.
Okay, thanks. One other question, and let me I'm a little lost on why we even have to have two versions. I mean, as I followed it through the material and as I've listened to the discussion tonight, it's like you put out a version and then there were people who said, well, that's a little ambiguous, or that might not be the best way to do it. So you came up with a second version, which to me is much clearer. It feels a little confusing. Can't we just go with the most recent iteration that's the consensus of staff that ought to be the version?
Maybe Lauren could speak to that one. I know we included the first version in the notice to the DLCD and the required notices, and there wasn't enough time to pivot at that point. Maybe Lauren can speak to what options are going forward for choosing one version or the other.
Thanks, Commissioner Beeson. I realized that I should have introduced myself the first time I spoke. Lauren Summers, Assistant City Attorney. Yes, Rita is correct. The reason that you're seeing two versions in your public hearing packet is because the original version was what was provided to the Department of Land Conservation and Development as part of the formal land use adoption process. And so that is the version that was noticed to the department, and they also maintain a list of folks who they notice for land use actions within the city of Eugene. So that was the version that they sent out to their list. And that is what we essentially told everyone the public hearing would be held on. But then kind of between that time and the time of the public hearing, based on input from folks in the community, based on staff reevaluation, it became clear that the initial version is no longer, it had some issues, is no longer the staff recommended version. But we still needed to kind of keep that initial version in play for the public hearing because of those original notices. Moving forward, the Planning Commission has all kinds of authority to make whatever recommendation you want. So you could recommend that the City Council adopt version 2, or you could recommend that the City Council adopt some other version that you like better. So you have lots of flexibility, but we wanted to make sure, knowing too that staff was no longer recommending version 1, staff wanted to make sure that version 2 was kind of out in the community prior to the public hearing to give interested parties some notice that there would be a second version, to give them some opportunity if they wanted to comment on it at the public hearing. And then also, as you've decided to leave the record open, they have an additional opportunity now to comment on it in writing following the public hearing. So we were trying to kind of do the best we could to make sure that we hit all the legal requirements and also were as transparent as possible.
So I guess we can kind of just, as we go into deliberations, we can kind of sort that out. Okay, that's That's good for now. Thank you.
Okay, Commissioner Bailing.
Thank you, Commissioner Lear. I was looking for some clarification. Jim New made reference to climate recovery and several other issues that did not sound to me like they were particularly related to what we're dealing with, what we're considering right now. And I wonder, and I didn't understand all of it. I wonder if any of you can explain to me if what he was referencing is relevant to these code amendments.
I'm not sure if anyone else on the team is familiar with what he was discussing, but yeah, that's not in my wheelhouse as someone that works with the land use code.
I'll just take a quick response at that and just say that, the land use code is one tool for, implementing the city's vision and things of that nature. But there's a whole set of other teams, whether that's our public works team who's doing the hazard risk analysis work. And then there's our whole, then that includes our sustainability team and as well as the work of the Sustainability Commission. And so, while our work is focused purely in the lane of like, what can the land use code do? There are many other city documents that help guide policy relative to, climate change, the impacts of pollution, things of that nature, such as the Climate Action Plan, and other such documents. So I think that was probably it's a lot about the larger picture coordination was kind of the notes that I was taking away from that. But really focusing on the land use code amendments today, and Jim is more than welcome to submit clarifying testimony if that's helpful. And this meeting's also recorded, so we can go back and watch that as well. But the amendments today are more about that initial step of coordination, and letting the next set of research and analysis kind of help drive where we go from here. If that's helpful, hopefully.
Commissioner Bailing, any other questions? And Commissioner Edwards, if you don't mind, maybe we'll give Commissioner Yang a go, and then you can be the next up. Commissioner Yang, if you're ready.
Yes, thank you for the opportunity. I have just two brief questions. Because the purpose of this amendment is to improve coordination, and part of the coordination is coordination in terms of timing, I guess, for these projects or requests. So specifically for the category 2, where the applicants have to prove that they have submitted application, what's the turnover time for these individual agencies to return with their proof or documentation? Can someone address that?
Yeah, thank you for the question, Commissioner Yang. So the whole permitting process can take a different number of days depending on what level of permit they're requiring and whether they actually need to go to like a public hearing for the level of permits. But what the version 2 is offering is if they are slowly going through that process, they can submit evidence that they've applied for the permits. And then while the permits through LRAPA or DEQ are being processed, they can also apply for building permits, and that would be sufficient to go forward. Alternatively, they can have a pre-scoping meeting with those agencies and find out if they don't need any of these permits, and then they will get that indication, and they'll be able to submit that with their permit or their building permit applications with the city, and then we wouldn't have to require any additional action. So the goal with the second version is to streamline it and not delay any development, because they can either show that they have the permits, that they've submitted for the permits, or they don't need the permits. And all of that should be able to be handled early on in the process.
I see. That's why I heard a couple of times they reassure that there shouldn't be any delay in the process by doing this. That's okay. Great. Thanks. My second question is that there's a definition where it says prior to city approval of any development permit. So my understanding is that this serves as a hard stop, meaning that any application. Is there any threshold or trigger that does not require getting the LRAPA or DEQ approval, or any development, like literally any?
So yeah, the code standards would, that third option in version 2 says that if they don't need a development permit, they could submit evidence that demonstrates that at the beginning. So both DEQ and LRAPA have meeting or pre-application informational meetings where they look at the scope of whatever the proposed use is and determine if it does rise to the level of triggering a permit requirement. So some uses wouldn't trigger that requirement, and so it really is dependent on what the specific use is being proposed there, what size it is, what type of impact it's going to have, and then LRAPA and the DEQ would be able to report back to the applicant and say, yes, this does require this level of permit, or no, it doesn't require any permit at all.
That's great. So that itself is the threshold. Got it. Thanks.
Commissioner Edwards.
Thank you again. Okay, so Rita, I think it's probably a question for you. Referencing like your slide number 7, where you basically lays out that the concerns brought up with J.H. Baxter, and I mean, we all know folks weren't following the rules, and the rules are there, and doesn't matter what we put into the code when people aren't following it. I'm curious. I am still kind of curious about the problem we're trying to solve. That I maintain that. I still don't understand why we're trying to use land use to somehow support the coordination approach and whatnot. But I have a question about why, whether or not there is a reason that we are not wanting to look at the risk and hazards analysis and that work and go into a more complete package of changes. We know how hard it is to go up in and open the code and have planning commission public hearings and then council public hearings. And I'm just wondering if there was a reason why, because it doesn't sound like there's this major sense of urgency, given that it's not going to avoid situations like that. And it really is just codifying things that are already happening, because the coordination is already happening with all these agencies. And so I'm just curious as to, is there a reason why we couldn't wait for that, the results of that, to move something more comprehensive forward?
Thank you for the question, Commissioner Edwards. Ultimately, that is up to the Planning Commission's discretion on how they want to provide guidance to the City Council moving forward. My understanding is that there was some interest in the community to move quicker while we were waiting on the results of the hazard and risk analysis. We conducted a lot of feedback and talked to a lot of different community groups. This was the one component that did receive somewhat broad support, because it's, like you said, it's things that people that know what the rules are, they're doing anyway. What this is trying to catch is people that don't really understand that there is DQ and LRAPA permit requirements for their proposed use. And this would give the city a trigger to get the applicant to do those pre-application meetings to determine whether they do need those permits. So for a lot of the businesses that have money to spend on environmental compliance officers, it's not going to change that. They already know what they're supposed to do. This is more getting at the people that don't understand what all of the permitting requirements are, and also that it's giving staff an ability to understand what permits are being required by other regulatory agencies, because currently we don't even know what the process is going on at other agencies, and we'll get questions about it, but not even have really an understanding of what's going on with those other permits.
Okay. And just as a really quick follow-up, I think for me, it would be helpful to know if we could quantify that. Like how many people are we talking about? What businesses are we talking about? What folks are, trying to go through a process and not knowing there's rules that they're supposed to follow. I haven't heard that explained, or even, that's never come out as a problem that we need to solve. It's like, oh, there's all these people over here without permits and they didn't even know they needed them. That's what I'm hearing from you. And I'm just kind of curious, like, can we quantify that? Can we hear from all of the regulatory agencies or folks that do actually do the, they're the ones who police that they're the ones that enforce that? Where are the problems that this could then, I just think it would really be helpful for me, at least, and to understand if there's a problem out there that the city can intervene and say, oh gosh, you didn't know that you needed air quality permits because now you're trying to get a land use permit, and we can head that off. But is that a problem? And so to me, it would just be helpful if we had that kind of feedback, or maybe in your, in all your work that you've done. And I know you've done a tremendous amount, and I really appreciate you've done a lot of work. So.
No, I appreciate that. And I could definitely follow up with some of our regulatory partners and find out if there is any sort of ability to track those situations so that we can provide that information down the line.
And just for some additional context too, I mean, the code amendments before you are a reflection of City Council's direction to staff. And so I just don't want to let that get lost in the conversation too, that's and then it's before the commission to do exactly the work that you're doing today, which is to ask questions, deliberate, think about how this moves forward.
Let me jump in for a second, Commissioner Beeson, and I'll pass it over to you. Rita, what would be your response to the testimony from Mr. Knudsen?
I think most of the testimony I got from Mr. Knudsen with El Rapa is the concerns about the timing. And I think that's just misunderstanding, and maybe we weren't clear enough in an explanation of the code, but that's the timing regarding signing off on those land use compatibility statements. So in order to get an LRAP or DEQ permit, when applicants go to them, there is a local approval that is required that gets kicked back to the city. And that's something that we sign off on irrespective of the building permit or development permit process. We just check the land use code table to determine if it's a permitted use or not. And none of these changes are going to impact our ability to sign off on those land use compatibility statements. So I don't believe that it does create that loop, but that's something we can, we're going to continue to have further discussions from our partners too. And I see Lauren has her hands up. She must have something to add.
And can I ask one clarification on that first, which is just if the representative from El Rapa is concerned that it's creating a loop and that's supposed to be the partner, I mean, is there any thought about pausing and maybe digging a little bit deeper into this before we move forward onto deliberation?
We haven't discussed that, but we are still actively working with El Rapa and DEQ and getting feedback and working out the logistics of this. So those are definitely conversations we're going to have going forward with them.
Sorry to cut you off, Lauren.
Oh, yeah, I would offer a couple of things. One is that your deliberations aren't scheduled for a month, so there's some time to have continued conversation. And again, Planning Commission has determined to leave the Planning Commission record open for 2 more weeks. So there's opportunity for discussion and also for El Rapa to clarify their comments in writing if that's something that they would like to do. I will say that one piece of the puzzle may be that development permit is, we use it colloquially sometimes, but it is actually a defined term in the land use code, and it is specific to a permit authorized or required by the Oregon Structural Specialty Code and Oregon 1 and 2 Family Dwelling Code, so the building codes. Including but not limited to permits for new buildings, additional square footage, building demolition, foundations, grading and fill, site improvements. So there's a list of the types of permits that we're talking about when we talk about development permits. And it is a specific list, and it is permits that are required by the building codes. And to my knowledge, and I would be very interested to hear from El Rapa if they understand differently, but to my knowledge, that would not include a LUX, the land use compatibility statement that the city sends back to El Rapa saying this use, this coffee shop, this industrial use, whatever, is allowed by the land use code in this zone on this particular site. Those are kind of 2 different pieces. So I would agree with Reed that I don't think currently, based on my current knowledge, that there's a timing issue that this would create. But that said, I would be very interested in hearing more from El Rapa for exactly the reason that you point out, that they are A, government partner, and B, are the ones who are tasked with enforcing many of these regulations. And so I don't think we want to make life harder for them. But I do think there's time to continue to have those conversations and for them to submit further written testimony prior to your deliberations.
I had just one more question. I'll pass it over to Commissioner Beeson, which is how much additional time and effort do you think that either version of this would create for planning staff?
It's hard to tell exactly, but it's basically with version 2, we're looking at checking a box, basically. So the applicant can either show that they have already obtained their permits, so that's going to be a pretty easy to provide that, or they can demonstrate that they've applied for the permits, and that could be done by having that pre-application informational meetings to determine which permit are required, and then they show that they have actually applied for those required permits. Or the third option would be showing that they've had that pre-application informational meeting and that no permits are required for their scope. So it would be mostly on the applicant of doing those checks ahead of time to make sure that they're off on the right track with any of their permitting that is required through DEQ and LRAPA. So it's something that they should be doing at the beginning of the process anyway to determine what permits are needed, because sometimes some of what is needed for those permits actually does come back around in building code or other requirements that would be a part of the development permit. So it really should be a introductory check the box right at the beginning of the permit review process.
So just to understand then, so I'm assuming that these permit applications are very beefy documents. So they're going to send over a copy of the permit application, and then will the planning department go through to determine whether or not that application has been reasonably completed, or will you be looking for another form, another verification from LRAPA and from DEQ? What are the next steps, and how do they show that they've met this requirement?
Well, under version 2 of the code, they would be submitting that information from each of the agencies about which permits are required, and then they would submit proof that they have applied for those permits. So yeah, it would be those two components as far as to meet version 2, or they would be submitting the second option of version 2, excuse me, or they'd be submitting that information that no permits are required. Or if they have done all their permitting ahead of time, which some applicants do get everything squared away, they would just submit that they have obtained their permits. So that would be.
It's like an incomplete submission, though. Is there someone making a judgment call about, 300-page permit and whether or not it's sufficiently complete to have been applied for? Or if they're turning in just the first page in order to say that they want to get the permit process started? Has that process been thought through at all?
We haven't dug into that specifically, but yeah, I thank you for the question there. I see your point that it could be circumvented by having a less than full application to those regulatory partners. That would be interesting to have those discussions with those agencies and find out how that might look if that were to happen, and whether we want to look into pivoting on the code language. That's something we can discuss and be happy to discuss further as we move forward with that.
Lauren, were you trying to jump in? I know we've got Commissioner Beeson, Commissioner Edwards, and Commissioner Yang as well.
I think, I see that Jeff unmuted himself as well, and I think he might be waiting to say the same thing that I am waiting to say, which is, it's a great question, Commissioner Lear, but like all of our approval criteria in the land use code, the burden is on the applicant to provide the city staff with enough evidence to show that they have met the approval criterion. And we don't articulate what exactly that evidence is in the land use code. They have to provide evidence sufficient to convince the decision maker that they've met the approval criterion. So in this case, one way of doing that would be to submit the completed application and say, yep, see, we submitted it, and it has a received stamp from LRAPA, and it, is the full application. There may be other ways of providing evidence that an application has been submitted, including maybe an email from agency staff saying, yes, we have received your application, or something else. But we don't typically get into that level of detail in the code.
Jeff, did you want to add to that as well before we go back to the commissioners?
Lauren and I are on the same page there. I mean, I kind of mentioned it a little bit earlier, but it's like, this isn't our code or our applications to vet. Our standard is, did they submit documentation for that? And so we don't know what a complete application looks like for LRAPA. We just want to know that there is one if they submitted it, and that gives somebody interested in that application to go the ability to go ask LRAPA, like, hey, did they finish that permit? Is that done? This is a coordination piece, and doesn't put their review process in our hands. It's not the intent.
Appreciate that. And maybe for our next meeting, and if there's any changes, just some more clarity about whether this is like a quick process or they're going to need a letter back from the other agency or a form back. I think that's really a lot of the beef that I'd like to wrap my head around. Commissioner Beeson?
Thanks. I have two questions. As I went through the material, we talk in there about being sure permits are in place or else applied for, and then at times it references agencies like LRAPA and DEQ. And I guess my question, I just want to clarify, in terms of regulations that have to be complied with by a business that is going into operation, where there are these where LRAPA or DEQ are involved. Are there any other agencies at all that issue regulatory permits that might? Are they the only two?
Thank you for the question, Commissioner Beeson. And it's a tricky question. Those are the primary agencies in our local community that issue air, water, and land quality and pollution permits, we found. And that's one of the reasons why when we transferred over to version 2, we did close in the bookends there just to have those two agencies. So we're not sending people on a potential wild goose chase to consider any other agencies. Those are going to be the primary agencies that regulate those impacts on our local businesses. So that's why we narrowed it down to those specific agencies.
Just to clarify, Commissioner Beeson, in version 2 of the proposed ordinance, the definition of air, land, and water permits and licenses is limited to permits and licenses issued by LRAPA and DEQ. Those are the only two agencies we're looking at.
Oh, okay. 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 So my other one's a little bit related. As I listened to, we have two versions. We talked about that a bit. I'm hearing a lot of discussion about the version 2 and this, whether permits are likely to be, and so on. I can understand there's a lot of kind of nuance there to plow through. I saw a reference to this in some of the material that was in the community summary, and it also kind of occurred to me as I was going through it. Why can't we, and Lauren, I'm not deliberating here. I'm trying very carefully not to deliberate. So this is, I guess, and I don't mean to suggest or write one tonight, but what about having a requirement that anybody who's starting some business or operation, that all required permits are in place before they begin operation, and you would tie that to the occupancy permit. And then you'd sort of avoid all of this discussion on the front end. It seems like, and I'm putting a premise on that for myself, that we'd want to be sure anyone in the industry operating inside our community had obtained and was complying with any necessary permit. And assuming that statement is generally true, isn't it possible we could just tie it on the other end? They just can't go into operation until they have the permits?
That is a good question.
Just a hypothetical, a question.
Yeah, I am not so much on the enforcement side of things, so that would create an enforcement situation. And I know, I think Lauren's looked into this a little bit with coming at the end of the building permit process to try to hold up occupancy or operations due to this requirement could potentially pose some challenges. But yeah.
Okay.
Yeah.
It just seems like, it could be pretty significant if they didn't actually have a permit to do whatever they were going to do. But I'll just leave it at that. Maybe I can think about it some more and we can. Okay.
I'll jump in.
Commissioner Edwards, thanks.
I know the answer, but I'm gonna. I know this. that oftentimes the permits are acquired when a business is expanding. So they're already operating, but they maybe are building onto their warehouse. And now all of a sudden they have doubled the size of their distribution. And now they've got a new set of permitting requirements by DEQ because of the trips that are going to be generated by freight and things like that. So I'm not, don't count that as an answer, but I'm just saying that sometimes like it's not the operational, but anyhow, I just thought I would attempt to clarify at least what I've learned about this process.
No, that's good. Yeah, that's good. I know these things always, the more we get into them, the more complicated they become, which is always fascinating, but all right.
My question is around assuming that, I think we're assuming that permits are always known ahead of time. And I think that just understanding, I would imagine it's not outside the realm of possibility that oftentimes an applicant, because the regulatory environment is based on something that they're doing in their processing. It's not the fact that they're a cabinet maker. It's a fact that they are using lacquers that need to be permitted because of the way that they have to dispose of those things or store them or all kinds of different things. And I'm just curious if it's possible that they don't always know at the point in time that they're looking to acquire their land use permits to move forward and build out a site and whatnot. And maybe they're not determining how exactly they're manufacturing their product or how they're disposing of things at that time. It's just a question, is whether or not it's always going to be the case that you're going to know exactly what permits you need before you even break ground. Because to me, that doesn't sound like that would be known all the time. So it would seem problematic if that's not the case.
Well, I can't speak directly to our regulatory partners, but they did indicate to me that they both offer pre-application informational scoping meetings. So what the applicant would do is they'd explain what their build out for, even if they're doing it in phases, they'd explain what's components of each phase are, and then the regulatory agency would look into that and determine what level, if any, of permit is required for that specific development. And then we would be, as staff, when those development permits come in, checking to make sure that whatever scope that they applied for the regulatory agency permit matches up what the scope of the development permit that we've received in the city.
Okay, that was my question. Thank you.
Commissioner Yang?
Thank you. I have a quick comment and then a question. The quick comment is that, earlier Commissioner Edwards mentioned that it's good to have some kind of number, quantitative, factor about the scope of things. And I kind of agree with that. I think it's one thing that our goal is to, incorporate this improved coordination, set standard, become a protocol between different agencies going forward. That's totally fine. But it's good to have certain context so we don't think that there's an epidemic of businesses, getting permits and operating without permits. And I could sense that could be an impression. And so I think that that's important to have some context. My question is coming back to the executive director, Travis of El Rapa, where he was talking about the suggestion of alternative languages and the loop and all that. And he mentioned something that's called the application consultation, which is what they do. And then you talk about there's a pre-application information meeting. And it sounds to me that they're actually the same kind of purpose, same kind of meeting, but just held by different agencies or entities. And I could be totally wrong. And I felt that if I'm one of the applicants, I would really benefit from some kind of navigation process that's coordinated. So I wonder if the person, who give the pre-application information meeting, could be a joint appointment with the applicant and the person who runs the application consultation for El Rapa, and kind of figure out what the applicant need to proceed forward. And I think that would be really beneficial. And so it won't be really a loop. No, you go first. Without you, I can't go forward. No, you go first. Seems like it's a similar purpose kind of meeting. It's all. Thank you.
And thank you, Commissioner Yang. That the terminology I use is different than what Travis Knudsen used, but I think we're talking about the same meeting. This would be, I think his suggestion was to add code language that requires applicants to have this specific pre-application meeting that they discussed, where our thought where the code is that the code requires them to show that they've submitted the permit or that they don't need a permit, so that we'd be providing guidance that here's the meeting that you go have with LRAP or DQ so that you can get this information. But just the difference here is whether we actually put that language to require the meeting in the code or require it to show that they've submitted for the permits or don't need a permit. So I think they both kind of get to the same end result, just we aren't specifically requiring that meeting just because. And also, if we were to put some sort of language in the code that this specific meeting has changed, and then they change the name of the meeting later on, then all of a sudden the code wouldn't apply and require that meeting again, which is the same situation we saw in the Clear Lake overlay zone. There's actually a code requirement to get a LRAP a pre-clearance letter prior to getting a development permit in the Clear Lake overlay zone. But our understanding is that LRAP doesn't offer a pre-clearance letter anymore. They have substituted it with these informational meetings prior to application. So we're just thinking that would alleviate going back and having to change the code every time the partners change the name of this meeting.
Commissioner Bradley?
Yes, thank you. Commissioner Edwards got me thinking about her questions about businesses operating without permit. And I think we're talking about apples and oranges, because for land use, we're talking about building permits, right? The developer could say he wants to build an industrial park and apply for the building permits and the LRAPA and the DEQ, et cetera. But that does not address the occupants that will later come along to do business in that industrial park. And I assume those businesses have to go through a process of getting their businesses licensed. And it would be very important, and probably comes after the hazard and risk analysis, that some other entity, wherever those business permits get issued, that they're also addressing these concerns for air and water and land quality. So I think it's a different entity, and we're not dealing with that at this point. Do I understand correctly?
Thank you for the question. So I think what you're just, so we call it basically, it would be a shell permit. So if an industrial developer wanted to come and build out an industrial site without knowledge of which each individual tenant is going to be, they could do so. So then we would be looking at what are they proposing as far as the structure, parking, any other features that they're proposing as far as not specific to each tenant's space. That would then we would require that they show us that they've had conversations with LRAB and DEQ, that whatever that proposal is complies, or that they've applied for any permits that are needed for that specific use. When it gets time to actually have a business occupant moving into one of these sites, they'll get what's called a tenant infill permit, which is a different type of a development permit, but they're specifically looking at what that use is, what occupancy rating is required for that use. And then it's another set of review that would come into play at that point. And then we would be checking to make sure that they also have had those meetings with LRAB and DEQ, and that they are working on any permits that are required for that specific use.
Great, thank you. My other question is, in our option for having proof that permits have been applied for, what would happen if LRAPA or DEQ denies the permit?
If they denied a permit, that would be something they wouldn't be able to open up with whatever the proposed use was. again, that would be LRAPA or DEQ's call to make that. It would be outside of the development permit process that the city would be reviewing, but they would be prohibited from opening under those other requirements that are enforced by those other agencies.
But in version 2, if they've proved that they applied for the permits, that would be enough for the city to proceed with issuing a building permit or a development permit.
I mean, ultimately, it would be if they met those standards, but those other regulatory agencies have actually pretty strong enforcement capabilities that are kind of go above and beyond what the city has. So the thought would be that they would be risking enforcement action from those other agencies if they took any action to violate their denial of that permit.
And that information would come back to the city, yes?
Well, that's the whole goal is to have an understanding of what permits are needed and that we can be tracking to make sure that they are going through that process. Just because prior to this, we don't really have a lot of coordination between the other agencies. So we've been under the assumption that applicants know what they're supposed to apply for and that they are doing it. This is just that additional check and helps create that transparency that we are up on board about what all the other requirements that they're going through with our regulatory partners.
Great. Thank you.
Just to put a finer point on that, I want to make sure that everybody is clear that we are not the regulatory agencies for these air and water and land permits that we're talking about. It's not part of our tracking measure. Like I kind of brought in earlier, this is a transparency and coordination piece, but we don't have the authority to not to unissue a building permit or take that back. It's really just making sure that people understand the scope and the world of permits that are being applied for. And so it's like that development can move forward so long as they meet our land use code. But as Reed mentioned, it's their operations and those characteristics that would be up to the agency that has the regulatory authority to stop them. It'd be their measure. And it's not our intent to track these things over time through this code, through this specific code measure.
I've got a question there, and then we'll pass it off to Commissioner Beeson. So I'm just trying to kind of understand the sequence. As of now, someone may move into one of these industrial zones. They're applying for permits, and normally they would, choose the timing of their application to LRAPA and DEQ, potentially later in the process. Maybe they start the design process. Maybe they even start the construction process, which can be several years. So is there any concern about, and maybe you could summarize if there was some feedback from community folks about taking away that decision on timing from the developer for the one who's seeking the permit, and I guess I just asked that because I'm still kind of a little struggling to understand the why on this one, since as it's been noted, there's no real enforcement mechanism or teeth, but it definitely will potentially cost some flexibility. So I guess I'm just trying to understand if there was a decent amount of feedback or any feedback shared about concerns there, or if it's something that's not a concern.
So the feedback related to this, originally we discussed requiring the permits be obtained prior to getting a building permit submittal. And the feedback from that was that would potentially slow down the permitting process in certain circumstances when they wanted or potential applicants wanted to do some work on the site, but not work that was going to rise to the level of triggering the need to have these air permits or land or water quality permits in hand. But they do need to be starting the process of obtaining the permits. And so that's why the original instruction was to add the likely to obtain process in there to give that flexibility so that we weren't holding up applicants. But then as we've discussed, the feedback was that was not a very clear or objective standard. It did not allow the specificity that applicants would need. So the thought with this pivot is that they should be having those conversations with LRAP and DEQ ahead of time to understand what the full permitting requirement is. Those are services that LRAP and DEQ offer prior to permit submittal on their end. So then we'd have a better understanding right when they want to come in for building permits, what other permits are required by those other agencies.
And just a quick question, if you got it, do you have any sense of how long it might typically take to put together one of those permit applications?
I do not have information on that now.
Okay. Commissioner Beeson?
Yeah, one last question. I guess I'm kind of trying to get a handle on the sort of the universe of possible land use code amendments in this arena that might be available or might be options to look at. There was reference in some of the material of back a few years ago, we were looking at gas stations, and maybe this is a question for Jeff. I saw that I think that staff was going to be maybe coming back to council and talking about, I guess, options in the land use code for how we might regulate gas stations. Was that ever done? Is that work been done? Do we have, anyway, that's kind of my question. Is that available?
I'll just say, one, that this response is a little bit outside of the realm and scope of the public hearing kind of before us, but just for informational purposes, the gas stations conversation, we are going to go back to council at some point for a work session on that. I believe that's been a request to us. However, that question's kind of been rolled up in with the hazard risk analysis, because that's the work that's kind of the bigger picture here. You know, it's like staff, like as much as I loved presenting on gas stations, I'm not an expert, and we really wanted to roll that into that full analysis. So that's likely outside of the scope of kind of what we're after today, but will likely come back to us through that process.
No, thanks. It does feel like it would fit better under the risk and hazard analysis. Anyway, thank you.
I muted Commissioner Chair Lear.
Thanks, Jeff. Appreciate that. Any other commissioners have comments you wish to share or questions you want to ask? We've got a few minutes left. Looks like none. So thank you all for joining us and speaking tonight. We'll be back on November 18th to begin our deliberations on this item. Is that still the date that we're slotted for?
That's correct.
Perfect. As mentioned, any written testimony provided by 5 p.m. on October 28th will be given to us, and any written testimony submitted after that time will be provided directly to City Council. This meeting of the Planning Commission is now adjourned.
Good to see everyone.